Well, good morning. I guess we'll get started. My name is Andrea Lee. I'm a partner at Glaholt LLP. Thank you for attending today by webcast and in person. Today is the second of a series of 3 series as part of our Glaholt Leadership Series. The topic today will be construction claims and working with experts. So just in broad brushstrokes, what we'll be talking about today is the retainer of experts, working with them and best practices for doing so, and how the involvement of an expert might change with the introduction of a new statutory education regime. And finally, we will be talking about best practices for document management throughout the course of the project. So leading today's panel discussion is Lena Wang and Derek Dodgson, our associates. And
hello, everyone. Yes. Well, thank you for coming and good morning. As Andrea said, my name is Lena Wang. I'm an associate at Glaholt, and my colleague Derek and I will be moderating this morning's panel. I'll begin by introducing our panelists. To my left is Ali Al-Ahmad. Ali is a director in the Forensic and Litigation Consulting practice at FTI Consulting in Toronto. Ali has extensive experience in preparing and evaluating construction claims and expert reports. He has worked with contractors, suppliers, public and private developers, law firms, insurance companies, as well as many others. His diverse project experience includes hospitals, bridges, airports, mines, oil refineries, generating stations, and many more. He specializes in performing forensic delay analysis on complex, large-scale projects, and is also conversant with various productivity studies and damage quantification methods. Ali has a Bachelor of Civil Engineering with a specialization in civil infrastructure and a Master of Business Administration with a concentration in finance. Welcome, Ali. To Ali's left is John Margie. John Margie is a partner at Glaholt LLP and is certified by the Law Society of Upper Canada as a specialist in construction law. Since John's call to the bar in 1995, he has practiced exclusively in construction and surety bond law, including complex international construction disputes, construction claims, construction liens, trust claims, and surety bond claims. John has been involved in disputes related to large infrastructure, industrial, and commercial projects, including hydroelectric projects, pipelines, mines, power plants, hospitals, waste and recycling treatment plants, roadworks, sewer and water main projects, and large commercial buildings. John is a fellow of the Canadian College of Construction Lawyers and has authored articles related to construction law, construction lien in Ontario, and construction litigation. Welcome, John.
Good morning, Lena. Thank you.
Good morning. And next to John is Steve. Steve Whitlaw is a partner in EY's Fraud Investigation and Dispute Services practice and has led several high-profile construction-related disputes and investigations. Steve's civil litigation experience includes business valuations, quantification of damages from contract disputes, loss of profit calculations, and construction delay claims. Steve is EY's public sector leader for fraud investigation and dispute services, focused on all levels of government in Canada. His expertise extends to the investigation of various types of wrongdoing, procurement activities, assessment of costs, claim under government construction contracts and lease arrangements, as well as the calculation of damages arising from disputes related to government contracts. Steve is certified as an expert in forensic accounting by the Canadian and U.S. CPA associations. Welcome, Steve. And last, to Steve's left, is Brendan Bowles.
And least.
Not at all least, Brendan. Brendan Bowles is a partner at Glaholt LLP and is certified by the Law Society of Upper Canada as a specialist in construction law. Brendan acts for a variety of clients, including subcontractors and suppliers, general contractors, owners, design professionals, sureties, and insurers. He has experience conducting motions and trials in the Ontario Superior Court of Justice and appellate experience up to and including the Ontario Court of Appeal. Brendan has represented owners, sureties, subcontractors, and suppliers, general contractors, and design professionals. He has taught construction law at Ryerson University and George Brown College. In 2017, Brendan was admitted as a fellow to the Canadian College of Construction Lawyers, and Brendan is a frequent speaker on construction law and was an executive of the Construction and Infrastructure Law section of the Ontario Bar Association. Welcome, Brendan.
Thank you, Lena, and good morning, everyone.
Okay, so we'll get started and dive right in. To start, we're going to consider a hypothetical situation in which a client approaches a lawyer with a dispute. The first question goes to you, John. At what stages of a dispute should you consider the need for expert evidence?
Lena, that's an excellent question. I find that construction projects are so complex that almost immediately when you meet with the client for the first time, you start assessing, as the client starts telling you what happened on the project, you start assessing whether or not you need an expert. As the client starts to give you details of what occurred during the project, my practice is to kind of typically make notes in the margin about some of these issues and whether or not we're going to need an expert to address them. For example, if the client describes that there were many deficiencies or there's an allegation of deficiencies, so right away you're thinking, I'm probably going to need some expert to address those, and then the cost of those deficiencies. Technical issues can also be described. Had a case in the past where the whole case turned on welds, and so you needed to identify at an early stage a welding expert that could testify to whether or not the welds were bad or good, or whether or not the welding procedure was proper. The idea being that the sooner that you can identify the issues for which you need an expert, I think the better off in the long run that the client will be.
Thanks, John. The next one goes to you, Brendan. What are some common issues in dispute for which the parties usually retain experts to provide expert evidence?
Yeah, no, in major construction claims, and I think particularly what we're seeing more and more of are kind of, not to belabor the obvious, but the gentleman we have on the panel with us, I think would be within the main issues that arise time and time again on major construction claims. And I'm thinking specifically, and I think often, like, how do I explain what I do to people when I meet them? Lay people at large ask me, what do you do for a living? You're a lawyer. Oh, do you handle divorce cases? Do you defend people charged with crimes? No, I'm a construction lawyer. What does that mean? Do you do something with real estate? Do you do something with injuries? Like, it's a difficult thing to understand. So I think often the way I explain it now, just based on the types of cases we're handling, is that it's often the case that construction does not finish on schedule. It doesn't finish on time, and time is money, to perhaps state the obvious. And you would think at the outset that somebody could devise a perfect set of contract terms and the parties would be absolutely on the same page in terms of, okay, what are the risks that the schedule's not going to be met? What are the risks that we're going to have cost overruns, and how do we divvy those up in a fair way? And there would be no conflict. Of course, we know life is not that simple. And time is money, and when the time gets bigger and bigger and bigger, the cost overruns get bigger and bigger and bigger, and the potential for fights just increases. And it gets more difficult to sort out later. So those are really the key things, time and money. Why is it that this construction schedule didn't get finished on time? And we think, sort of, what are first principles? Why do we have experts in our system at all? Like, why is it? It's because, just to get right back to the basic point, is that if you're at a trial or an arbitration hearing, a witness is only supposed to testify as to facts. They're not supposed to testify about opinions, because it's up to the judge or the arbitrator to form that opinion, to make that decision. But in the real world, particularly to get into a field like construction, there are technical issues that maybe your arbitrator might have some understanding of it, but not everyone can have understanding of something as complex as construction scheduling to the degree of an expert. Certainly a judge may not have any experience with that whatsoever. So they need that assistance of somebody who is qualified to give that expert opinion to the court on it. So absolutely, in modern construction with primavera schedules, the art and science that goes into that, it's absolutely the sort of thing that the court and even an arbitrator could not figure out themselves without the assistance of that expert opinion. So that's kind of number one. And then what are the costs that attach to that? For example, Is it that if the construction schedule hasn't been met, that the person asserting a claim is just entitled to claim everything, basically, that they could find in their books and records as additional costs in the claim? Well, that's often the approach that I take. Just disqualify that. But we need somebody like Steve to step in at that point. Somebody to assist us in understanding, okay, you know, the court is going to have to determine what is this worth. Somebody with the accounting expertise to be able to say that. So those two are absolutely fundamental, and I just see them time and time again in the cases. We need somebody like Ali to tell us what went wrong with this construction schedule, particularly where did the critical path run, and what events happened along the way that caused it to go off schedule, and then what damages attached to that. And then just to add to the fun in construction, and John alluded to this with his answer, is that on any project, particularly a bigger project, there's going to be a whole host of technical issues that are likely associated with what went wrong. And the clients in the room are thinking, oh dear, you know, when a lawyer says something like that, that just means we're going to add more experts to the team, we're going to add more costs. Well, in big cases that can happen though, because it can be very important. Like, you know, if something went wrong with the structural work, you probably need a structural expert. And you can imagine, you know, any number of technical issues that a judge or even an arbitrator would not have the expertise to be able to form their own opinion on.
Yeah. I would just add to Brendan that I think the best way to describe the third expert or set of experts relates to scope. So that way we've covered scope, price, and time, three fundamental elements of a contract.
Yes.
Thanks, Brendan and John. How do you search for potential experts when you've identified the need to retain experts? Maybe we'll start with you, Brendan, and then John to add.
Yeah, I think number one for me at this sort of stage of my career is have I worked with that expert before or with their firm before? And the answer might be counterintuitive in some ways. In some ways, depending on the case, that might be a good thing, particularly if we're going to mediation in 18 months or something like that, and we need to work really quickly together. A known quantity is a good thing, especially if the client knows and trusts that expert as well. That can work really, really well. On the other hand, you have to think, is this a case that has the potential to go to a hearing, particularly an arbitration process, where maybe the reality is you're in that arbitration process because you're going to need that arbitrator to decide. We're going to talk a lot about the need for impartiality this morning. That's obviously very, very key. It may be that, you know, using the same old, someone that's worked for you time and time again in the past, someone who's worked for the same client time and time again in the past, may not be the appropriate person for that retainer. You do need someone who is completely independent and fresh to the problem, perhaps. So you have to kind of think of those things. But definitely, you know, somebody that we've known and worked with before is going to be on our short list. Then again, just quickly, some other things that I would look at is, what is the person's or the firm's reputation? Do they have a reputation for being a hired gun that's brought in to maybe more on a consulting expert basis than a testifying expert basis, frankly, just help advocate for a particular cause and force an earlier settlement of a claim on site? And I'm not so naive, and I wouldn't say there's not a role for that in society, because not everything has to be litigated or arbitrated, for goodness sake. I mean, I understand there's a lot of stuff that just gets settled on a project level, and that's as it should be. Not everything needs to get escalated to a formal dispute resolution process, and those experts definitely have their role. On the other hand, for what we do, and if we're going to court, that impartiality is so important, because if you don't have it, the case can basically just collapse like a pierced balloon on itself. So we look at that. We also look at, are there any reported cases where the expert has testified before? That is important, but I don't think it's determinative, because again, the reality is with a lot of these construction claims, they do settle short of a trial. And arbitration cases typically are not reported. And if they are, it's because they've been appealed on some legalese point, not on really the meat and potatoes of the expert issues. And that expert may never be known. So it's important because you want to see, has this person been cross-examined before? And if it's not a reported case, we would likely ask our friends and colleagues who also practice in our area, other experts we know, has this person been exposed to the fire before, and how have they performed? The other thing I would add is that I definitely look at is this somebody that's published in their field? And is this somebody who has the ability to present and give seminars, teach classes, do things like this, candidly, on their chosen field of expertise? In other words, is there some element of peer review? Somebody has reviewed their work and said, yes, this is worthy of being published. And if so, that's a great sort of, if I could use the expression, almost underwriting technique. There's other people out there that have done the due diligence and homework for you. This person is someone who has a very good chance of being qualified as an expert, being trusted, their opinion being accepted, because they've been vetted in advance by virtue of being published, particularly if they've been frequently published. That's a very strong point to develop expertise.
Can I just jump in for a sec, Brent?
There's just one last thought,
Okay.
and then I'll start shutting up. Sorry. It's communication skills as well. If they're able to present and are asked to frequently present on their field, better chance of performing well at a mediation, arbitration, or a trial, for sure.
I just wanted to comment on having an expert who's extensively published, and you've got to be very careful to ensure that your expert that you're hiring has not written articles against a theory, for example, or perhaps a methodology that you want to pursue in your case, because then it just makes it very, you could just imagine what that cross-examination would be like of that expert, because they'll pull out the article and they'll put it to the expert that, here's your article, you said that this methodology is junk science, and here you are today in court forwarding a claim based on what you called junk science. So you've got to be very careful about that.
I'm seeing that in cases where it's the accounting experts are testifying, actually testifying in a case about an appropriate approach to valuation or an appropriate approach to costing, and then in the next case they're taking a totally different position,
yeah.
and they have to try to defend that, and it's not usually
Yeah.
very successful. So.
Yeah, and I guess that's the thing. You almost got to think in a paranoid sort of way with these things. Like, if you had somebody, let's hypothetically call them John Margie, someday cross-examining this person, what points of attack would they pursue? And if you start thinking of the problem that way, a lot of these answers become obvious. Again, if the person has advocated a completely different position, if they're testifying for the same person, they always testify, and that person just always happens to be right. There's obvious points of attack.
Yes.
Okay, so having heard from the lawyers in the room on where they would look for potential experts and what they would consider, Steve and Ali, I'm interested in if you have anything to add as to where lawyers should look when retaining potential experts. Maybe we'll start with you, Ali.
Sure. So one way, I guess, that's popular is to ask other experts that you've worked with in the past before, someone they trust. And especially in my field, in delay analysis, you want the expert to be familiar with different types of delay analysis. There are a few really important considerations. So one is the available project documents, and the second one is the value in dispute. So the project documents, you want to make sure that you have what's required to actually use the method you're using. So if you want to use a Windows analysis, you want to make sure you have contemporaneous schedule updates. And if you don't have those schedules and you have a very short amount of time to perform the analysis, well, you may resort to something a bit more basic, such as an as-planned versus an as-built. So you want your expert to be familiar with these different types of analyses. I think that's important.
Sure, thanks. Steve?
Yeah, first off, I think it's important, fundamentally that this decision-making process takes place early, because I think the experts being brought in can tend to be very helpful in progressing the case the way you want it to be there, and making sure that everything the expert's going to need is available for them in the period of time they've got to deal with. I think the other important thing you need to consider in your expert is the complexity of the case and the realization that financial numbers don't necessarily speak for themselves. So you have to really have an expert that you are comfortable with, can relate to a judge or interpret things in a manner that you think is going to be understandable to the court. And I think that asking, a theoretically assumed set of facts as part of your, interviewing up front and saying, how would you deal with these type of issues, to get a flavor for what they're going to come across at, and or asking for can you give me a chunk of a, edited report where you've dealt with something like this? I think that's fair. I think the other thing that's really important is in choosing an expert, the lawyers and the clients have to understand the complexities of the case. And if they don't understand the complexities of the case, they may not choose the correct expert. So in other words, you need to appreciate what your potentially is going to be at play in the claim. So if it's a simple delay, and I say simple, which they're not typically simple, but I mean if it's a delay case where it's just weeks of delay times rates in a contract type situation, that's one type of expert. Whereas if you're dealing with things like lost opportunities or lost labor forces or other items that could be included in the claim, then I think you need to look for a much more, deep-seated accounting expert who can speak to these type of things in these valuation type concepts.
Yeah. No, and you just remind me a quick little thing I'll just add to the mix is that I remember in one particular case, we were asked by the client to consult with somebody rather senior in the profession, and we actually, again, every case will be different. I wouldn't do this for a small claims court case, but for this particular case, we actually approached a retired Supreme Court of Canada judge and asked him for his opinion on what do you think we need to do? Like, because at the beginning of a case it can be difficult. You got a bunch of spaghetti you want to throw at the wall. Like, what are the actual specific questions of expertise though you want to pull out of that tangled mess? And he gave us advice on a particular type of expert that we would need in this case that he would want to see as a judge. So that was just, it was interesting. So I mean, you might want to think kind of creatively and reach outside the box a little bit. We're taught in law school, I'll give away a secret here, to figure out, okay, what's the result that you want to get to at the end of the case? And then, so if you know that, how do you build along the way to get to that result? So, if you don't ask, I guess maybe phone a friend. I wouldn't say every case requires consultation with retired Supreme Court of Canada judges, don't get me wrong, but just, I throw that out there. There's probably somebody who might be able to help.
Thanks, Brendan. So let's say a lawyer has identified the potential experts they would like to retain and arranged introductory meetings with them. John, what sort of questions should a lawyer ask before retaining an expert during this introductory meeting?
Yeah, thanks, Lena. Brendan's, I think, alluded to a couple of them when he mentioned experience testifying, whether or not the expert has published material. But I would also ask capacity. They might be the best expert in the world, but if they are so busy and they cannot afford any time to look or address your issues or your case, that's not going to be any good for you. I would ask the expert if they've ever had their evidence excluded due to bias. That, I think, is something that you have to consider today, especially the way the law has progressed. I would also ask the expert if their expertise has ever been challenged, and if so, what was the result of that challenge? Because you want to be able to shore up your expert's qualifications, if you will, if that's necessary. I would also ask the expert if they've ever had anything go to trial and whether or not there's a reported decision, so that you could search and find the case and see what a prior judge has said about the expert's qualifications and how the expert's report was received ultimately in evidence. Let's see, I'd ask them if they've ever worked with or against the opposing counsel on my specific file, just to see how that interplay was at that time. And I'd also ask them whether or not they've ever testified on matters that are very similar to the one that we're currently asking them to testify on. So those are kind of like a broad range of questions beyond, have you ever litigated this specific type of project, and have you ever done a delay analysis, that kind of thing.
Thanks, John. And Steve and Ali, having gone through this process, what do you find is a topic or questions that lawyers often overlook in these initial meetings? We'll start with Steve.
Yeah, I think fundamentally there's this fit question that doesn't seem to actually be brought up. Like there's always this ask for your, have you testified, have you done all these things? But then there's not the conceptual how we intend to proceed with the matter. So how are we going to share documents? What is the expectation on draft reports? All those kind of fundamental, this is not going to be a good fit or this is going to be a great fit because we're starting off on the same page. Mm-hmm. I think the other thing that it occurs, and a lot of these meetings actually tend to take place with the clients in the room. And I think there's a missed opportunity to get everybody on the same page. And again, the fit question as part of that meeting when you're talking to the expert, so that the expert, the client, and the lawyer involved all understand and appreciate how the expert's going to approach the matter and why they're going to do it that way. And so there's a general understanding of, that as a financial expert, I'm not there just to tick and box things. I'm there to actually try to make stress test this thing and make sure that the numbers pull together, and that prior to getting to trial or prior to getting to mediation, that we understand what the pros and the cons of our position are going to be, or the position of the client is going to be at that point.
Because in the long run, that helps you address the cons that you might have to face.
I'd much rather have to deal with it in my report than have it brought up to me in cross-examination, for example.
Absolutely.
Right? So,
Yeah.
and I think it's better for everybody. And I think it's better to quite frankly, to settle a case that you really understand, within that scope of what's being claimed and what, where your soft spots are and what that looks like from a numbers
But also,
perspective.
what's your leverage? What's
Right.
your leverage?
Exactly.
I mean, if you don't have leverage, I mean, how can you mediate? How
Right.
can you
Correct.
negotiate? So it's and I guess we'll get into it, not to step on the questions, but I think recent case law bears out that the courts now are a little bit more realistic about that you don't need to have an expert put in bubble wrap immediately and don't communicate, don't talk to anybody, just show up at court. Because we don't want you to be tainted or biased in any fashion. There's a bit more understanding now, I think, in the judiciary that, there has to be some of that interaction, as Steve points out, and we'll get into that.
Ali, do you have anything to add to questions or topics lawyers often overlook in these initial meetings?
Well, not something they overlook. I guess one thing is important, similar to what Steve is saying, is between fit and understanding exactly what your expert scope of expertise is, or their field of expertise. I gave the example of, with this one lawyer in Quebec, they had asked us, after we prepared a draft, to opine on the contractor's project management performance. That's something the owner had complained a lot during the project, how project performance was atrocious during the project. But that's not my expertise. I'm not a contractor, so I explained to the lawyer, well, this would actually be detrimental to your case if we included this in the report or in our analysis. We should stay within our boundaries, which is really delay and disruption of the file. So I think that mutual understanding, that fit between the lawyer's expectations and what the expert's field of expertise is really important.
Thanks, Ali. So to continue the hypothetical, so let's say now you've identified an expert and the client would like you to retain this expert. Let's discuss how to structure a retainer with an expert. First to you, Brendan, how would you define the scope and set it out in the retainer for an expert?
Yeah, no, and I think maybe just pausing for a second there, I think it's very important to consider who is this expert and on what basis they're being retained. Because it is possible to have different types of experts. You could have a consulting expert, for example, who is someone you're utterly unconcerned with having tainted or biased or whatnot. You want them to be. They are somebody who is going to be at the table with your client, trying to figure out how do we get the right documents together, how do we advocate the case. They're consulting with you to provide, if I can use the expression, almost a manpower solution to getting together the case that you ultimately want to put forward on an evidentiary basis. And in that circumstance, I think it's much more straightforward, and often, candidly, we'll just have the clients retain those consultants directly themselves, because that never gets into the record in any fashion. It is for the dominant purpose of litigation, which means that it's protected by litigation privilege, and that consultant is not brought forward to testify. But by the way, if you're hiring those sort of people, it's very important, I think, to make sure you have a good, strong confidentiality provision in there, because there's nothing worse than settling a case on highly confidential terms and then 2 years later finding out that your consultant is out sort of advertising their role and talking about what they did as your consultant behind the scenes on this highly sensitive private case. So you want to make sure they understand. They're at the table with you, they're an advocate with you, and they're locking in that confidentiality with you. That's important. So back to this world, though. If we're talking about a testifying expert, how do we do it? And I have to admit, my track record, if one were to observe it over the years, maybe isn't entirely consistent. Sometimes I tell different things to different people on different days. But in the course of preparing for a seminar like this one, consult some of the first principles and realizes, the right way to do it, I think, is to get at something Steve and John were talking about, is to have that early engagement. Don't be afraid of that, because I think the courts will tolerate that to a large degree. However, just one fundamental point is that the retainer letter is going to be produced to the court someday, or to the arbitrator someday. They're going to see that. And when you're dealing with folks like Ernst & Young, for example, to take a hypothetical, they probably have a very well-developed set of terms of retainer, terms and conditions that are used in all manner of expert retainers across the board. And there's no point in really reinventing the wheel. There may be some negotiation, but candidly, as a lawyer, your client probably has folks in-house who can handle that negotiation and come to acceptable commercial terms. So what they need really from you as a lawyer is a cover document that someday could be disclosed to that judge without any sort of fear of reproach, that sets out the scope, as Lena asked, of what it is they're being asked to do. So, for example, you've got to think very early on in the case, what is it that we're asking Ali to do for us here? Not just something that's going to be regrettable later, because we can't run away from that retainer letter. But let's think about, as I said, the destination we want to get to and how do we get there. How does Ali help us get there, for example? He helps us by saying, the question you're being asked is, why did this project go off schedule? What were the critical path events? What caused the delay? And in your analysis, what is the resulting recoverable delay for this person who's asserting the claim? You know, to put it in sort of very broad terms. But you want to think about focusing it and getting that right in the retainer letter. By all means, of course, have your clients, the experts' standard terms and conditions negotiated or not appended to that. Because in reality, we all got to get paid, we all got to work with each other. There's things like confidentiality, all the rest of it you want to put in there. But very important to have those clear questions that we can disclose to the judge later without fear of reprisal. I would say on the lawyer's letterhead at the top of that package. And you want to start off on the right foot. And it forces you to think, as I said, where do we want to end up and how do we get there?
Thanks, Brendan. John, who should the agreement be? Should it be between the expert and the client, or the expert and the lawyer?
I think the best way to put it, Lena, is to have almost like a tri-party agreement, so that, for example, it could be the standard conditions of Ernst & Young or FTI, but it's signed by all three parties, the expert, the client, and the lawyer. I think that's probably the best way to proceed. It just seems to make sense. And then, as Brendan was saying, and on top of that is bolted the lawyer's letter that attaches these terms and conditions.
All right. Thanks, everyone. We're going to move on now to some rules and guidelines for working with experts. So, Brendan, if you could start off by identifying what you think is one of the prime authorities you should consider as a lawyer when you're working with an expert.
Yeah, it's interesting. I talked about the case law. Like, there's the Genahan case, which I think we'll be talking about in a bit more detail. Recent Ontario Court of Appeal case. Interestingly, one of the authorities they consulted and relied upon in their decision was the Advocate Society paper on retaining experts. So certainly for anyone in the room who's a lawyer, if you're a member of the Advocate Society, you can get that paper from their website. Otherwise, I think for everyone in the room, I'd like to make that available on our website after the seminar so everyone can read it. Because, you know, I think for a lawyer's document from a lawyer's organization, it's remarkably clear and plain English and understandable to anyone, I think, actually.
Hard
if you'll permit me to sort of
hard to believe it's written by a group of lawyers.
Yeah, in a passively aggressive way, trash my own profession. But you know, again, the Ontario Court of Appeal put a lot of stock in it. So in some ways, literally, the law that we have in the province now on retainer of experts is largely derived from that paper. It's not the only source, but it was interesting they were able to pull together 9 principles, which I'm not going to bore you by listing all 9 of them. But you know, fundamentally, when we're talking about things like impartiality, why is that so important? When you start reading this and going through it, you realize, yes, at the end of the day, this whole enterprise could be undone like a string being pulled out from, you know, a tapestry, and it all comes unraveled if the court can't rely on this expert as being the objective person who's being a friend of the court to help them form an opinion on something they don't have the technical expertise to understand themselves. In other words, if there's somebody who's only looked at certain documents but not others, if there's someone who's considered only certain arguments but not others, there's this fundamental mistrust that gets introduced into the equation, which really, at the end of the day, we all want to play to win. And sometimes, you know, the thought is to play to win, I need to have my strongest foot forward and only my strongest. But in reality, you've got to be strategic. And if you're not playing the game according to that fundamental rule, it's just no point playing. So that paper, I think, really kind of ties all those things together.
Yeah,
So-
I think it's, I just want to comment on that because the bias issue is becoming so central. As Brendan said, you can watch your whole case unravel. In the news recently, the trial of the former chief of staff of the Liberal Party for destroying documents. I think it was 2 weeks ago. The judge threw out the expert report of the Crown's expert evidence on computer forensics. And as a result of that, the Crown now might not have any evidence that emails were actually destroyed because they were relying on that forensic expert to give that opinion that there was actual destruction of emails. And as a result of that, I found it very interesting reading the articles about it that the Crown required a 2-week adjournment of the trial because now they've got to go back and reassess their case and where it stands. And that's all thrown out on the issue of bias.
Yeah, and how can that happen? You know, in such a high-profile case with people as sophisticated as the Crown, you know, it's in public view. Like, how is it on earth could that happen? And it's because, I think, you know, I was joking with Steve beforehand. Like, it's almost like the way our system's set up. The expert's asked to be, you know, it's like we're asking you to be a tiger, but don't be a tiger. Yeah, right. Like, in other words, we're hiring you and paying you good money because we want to win this case. But on the other hand, whatever you do, you know, don't be on our side.
Exactly.
But that's the thing, and it's so counterintuitive, but in the end it's so true because it just gets back, and I'm like a broken record here, but it's, again, the fundamental principle of evidence is that, you know, it's only the court that gets to decide. Right. No one else does. But then, you know, in the real world, all of a sudden, things get more complex than one human being can possibly understand, certainly someone who went to law school. And you need that expert to help you understand, okay, what really went wrong with the schedule? So they don't want to understand like what the adversarial position is, why one party is entirely to blame for this construction project going off the rails without having considered all arguments and all documents fairly. They want to know, can I rely on this as a judge? And if they don't have that, they have nothing. And so you need to be strategic. You still play to win. You just play the rules, play the game according to the right rules.
So that's a good segue.
You follow the rules.
Yeah.
That's a really good segue into the duty of an expert under the rules of civil procedure. So Brendan, I wondered if you could just give a quick summary of that, and then we'll have John talk a little bit about the case law in Ontario and Canada.
Yeah, so basically there's two main things that I found, even, you know, almost 20 years after writing the bar exam, I still need to actually consult my paper on this. It's just the way my brain works, but it has to do with the fundamental principles that we've talked about, and I'll just read them because they're short. Number one is to provide opinion evidence that is fair, objective, and nonpartisan. So that's in the Ontario Rules of Civil Procedure, and that's codifying principles that we've been talking about. This friend of the court, not the advocate. To provide opinion evidence that is related only to matters that are within the expert's area of expertise. I don't think we've talked about that yet, but that's another very important theme. And I'm sorry, I just realized actually Ali raised a very excellent anecdote on that very point. And again, it's human nature versus this almost unnatural set of rules that we have on how to play this game. Human nature is I want to win, so I don't want to hear why I'm not paying you all this money to tell me why I'm wrong. I'm paying you all this money to tell me why I'm right. But the reality is, you need to be strategic. The expert needs to point out those flaws in the case so they're not pointed out for the first time on cross-examination. Oh, and by the way, so that the expert's report is capable of being received. Related only to matters that are within the expert's area of expertise. Again, human nature is sort of, this costs a heck of a lot of money. We're wasting a heck of a lot of money on this thing, frankly. We want to get it resolved. Can we find some ways to get the budget under control here? Let's just have Ali comment on the duties of a project manager, because he's a smart guy. He's with FTI. Like, why do we keep paying all these for working lawyers and experts, let's just do it. But the reality is that that's a fundamental problem, and the rules of civil procedure have codified that. And indeed, there is a form that, we're all becoming more and more familiar with because it gets included in that package of documents produced to the judge that I talked about that the expert has to sign that attests to these things. The only other thing I'd throw in, just for a laugh, is lawyers being lawyers, we can't resist putting in a third rule, which is to provide such additional assistance as the court may reasonably require to determine a matter at issue. What does that mean? That basically means, almost that in unforeseen circumstances, the court has discretion to do what it wants. I think, but that's lawyers being lawyers. We can't predict every possible circumstance that could arise, but those are kind of the two fundamental guardrails there, aren't they? Again, the expert better be within his or her field of expertise and not straying outside it, and the expert better be fair, objective, and nonpartisan.
Thanks, Brendan. So, John?
So this will be the law portion of this presentation, and I'll try and keep it really short because it is still early in the morning. So there's really only 3 cases that we need to consider ourselves with. 2 are from the Supreme Court of Canada, and 1 is from the Ontario's Court of Appeal. In the first Supreme Court of Canada case, the Mohan case from 1993, the issue was simply what are the criteria for the admission of expert evidence, and the court came out with 4 criteria. Relevance, the issue. The report has to be, or the evidence has to be relevant to an issue in the action. It's got to be necessary to assist the trial judge in making a decision. The third one is that there has to be no other rule that excludes this opinion evidence, and that's somewhat of a really technical criteria that in most construction cases doesn't apply. And the fourth one is that the expert is qualified to give the opinion that they are going to give to the court. And that's the area of expertise, and to ensure that your expert is opining on something that they are in fact an expert in. So move on many, many years later, in 2015, the issue of admissibility of experts report comes back before the Supreme Court of Canada, and they take the 4 same criteria and they say, yes, we like these 4 criteria, we'll continue to use them. But then they added, if you will, they added a second arm of the test. So first what they did is they took the 4 criteria, and to the 4th criteria, which is that the expert is qualified to give the opinion, they added to it that the expert is willing and able to fulfill their duty to the court to provide evidence that is impartial, independent, and unbiased. They then added a second arm to the test, and they indicated that the court is essentially a gatekeeper of expert opinion evidence. And in determining what the court is required to do is determine whether or not the evidence that they're going to receive from the expert outweighs potential risks of prejudice, for example, and that they should consider 4 factors when doing that: relevance, necessity, reliability, and absence of bias. And so what the Supreme Court of Canada did most recently is they made the issues of bias, impartiality, they made those very central, because I think what they'd seen over the many years since they decided the issue of admissibility is that more and more experts were being seen as hired guns. And the court does not want to see a hired gun anymore. They want someone who is impartial and is there to assist the court, understand the issue, and be able to give the opinion evidence. Then the third case, third and final case, is the Moore case, and that's from the Ontario Court of Appeal in 2015. And there were, for our purposes today, there were really 2 issues we need to address. The first related to whether a counsel can review a draft expert report. We'll talk a little bit more about this later this morning, but the answer is yes. And the court essentially just came out and said, yeah, we want lawyers to review expert reports, but you can't change the opinion or the conclusions, but what you can do is assist the expert to communicate their opinion effectively. And that's really the role of the lawyer in working with the expert, is to ensure that the expert's opinion evidence in the report is clearly communicated so that the judge, and if you happen to have a jury, would be able to understand it. And the second issue that was before Moore was related to the extent to which draft reports and communications between the lawyer and the expert are producible. And the court said generally no, they're not. They shouldn't be. However, unless there's good reason to do so. And so that would be where you're able to demonstrate that the expert is very biased to the party that they're giving evidence on behalf of. In that situation, then the court would look at it and assess whether the draft reports and the communication should be produced. And that's essentially the state of the law in Ontario and Canada where we stand now.
All right, thank you very much, John. And as Brendan alluded to, we're going
Did I
to
do it in a short period of time?
Yeah, no, that was excellent. Summarizing some very dense case law in a brief amount of time, so that's excellent.
It's a new record.
Yeah.
But you hit the right points.
Yeah, so we're going to make that case law and the Advocate Society guidelines available on our website for everyone to take a look at. But for the last question in this section, I'd like to turn back to our experts. And Ali, you mentioned a case of a report, going outside the scope and the implication that might have had on a report being thrown out for a lack of expertise. But I was wondering if either of you have seen other instances where an expert's report has been rejected or discarded for failing to follow one of these requirements that we've talked about today. So maybe start
Hopefully
with
not
Steve.
one of your own.
Exactly. I was going to start with the good news story is that hasn't been one of my reports, right? For sure. This is happening, quite frankly, shockingly too often, I think. And it tends to always relate back to the lack of independence and objectivity. So in other words, the expert hasn't done what they should have done, what the court expects them to do, from a challenging statements from the client, challenging assumed facts. The one thing, we're there as experts, we're the ones who should be the ones who are challenging these positions. And if we haven't done that, if we haven't asked the right questions, then we're in big trouble. The other interesting thing that we've seen and on a recent case, and it comes out of BC, which is a little bit of a different world for how these cases resolve themselves. But in that case, the judge actually said that the expert couldn't testify because they hadn't spent sufficient time on the file. So in other words, it was a partner in one of the big firms who had done like 5% of the hours on the file and said, you, sir, you don't know, you don't have enough to educate the court. I'm not going to let you testify. If you want to have your junior testify who spent 45% of the time on the file, I'm happy to hear that evidence. So, there's this other unique dynamic that as an expert, you're expected to have, been boots on the ground and got into the nitty gritty of these cases. So. Yep. Those are the two things. Ali, have you ever seen any other report?
Yeah, so it was around 3 years ago, again in Quebec. This is where I started my career. This case is public knowledge. There was a dispute between Hydro-Quebec and one of their contractors in James Bay, or Bay James. The contractor had hired an expert to prepare an expert report on delay and disruption on one of these hydroelectric dams. The opposing legal counsel, did their research, do what lawyers do, and discovered that not only had this expert who co-signed the report worked for Hydro-Quebec in the past, but he had actually accessed some of the files related to that specific project that he was not working on. His defense was that he inadvertently copied the files to an external hard drive. It wasn't on purpose, and the IT experts that the opposing counsel had engaged was actually able to determine exactly how many times this individual accessed those files. So in this case, obviously, the expert's report was thrown out. And then they actually took action against this individual, removed his engineering license to practice in Quebec.
Yeah, that's a severe sanction.
Yeah, it is.
Yeah.
Anyone else aware of any other cases of reports being thrown out? If not, we'll move on to our next section. It's more.
Or even first. Sorry to speak over. I apologize, but it just occurs to me the other one that would almost be worse is you go to the end of a trial, you have a lengthy reserve, or an arbitration hearing, lengthy reserve. You get the reasons back, and then you see all this bad stuff repeated in the judge or arbitrator's decision as to how the expert was unreliable. Not a friend of the court. They were an advocate for one side. They disregarded documents. And I don't want to be that guy to raise the McNamara case from Newfoundland again, but I guess I just did. But I won't say who the expert was. But I often thought, it was a major trial, weeks and weeks and weeks of trial in St. John's, lengthy reserve, trial
Lengthy
decision is-
decisions.
Yeah, and the decision was very long. I think it would take up an entire law report textbook itself. But the judge spent an extraordinary amount of time just excoriating this expert, who was somebody that, frankly, had a good reputation. And in fairness, I think that reputation has been, to a large extent, rehabilitated. But it was, man, you just think all the time and money invested in this. And it was that kind of human nature sort of inserting itself into it. You know, these guidelines and rules, let's, you know, not obsess about that. Let's obsess about putting what we think our best foot forward is. It just all came unraveled because the judge couldn't rely on it. And all that cost, effort, basically, for naught. And reputation hanging in the balance.
Yeah, but to the defense of the expert, the one thing we really don't know about, and that's never commented on in that decision, were the instructions that the expert was given. And so we go back to the retainer and the scope, and it's very important to understand what you're asking your expert to do and what effect that's going to have on them down the road, and like in this case, at decision.
Yeah.
A 175-page decision, I think.
Yeah, I think for anyone, you know, to say, wow, it's entirely your fault, I'm just going to walk away from a debacle
Right.
like that. Again, and that's why, you know, that letter from the cover of the lawyer is so important. And to challenge the lawyer, like, why are we asking these questions? Like, are these the right questions to ask?
Mm-hmm.
It's never too early to think about that. And I know, Steve, your perspective on it is, look, in light of sort of where the case law is at now, and we do have a bit of a safety zone
Right.
to exchange drafts, to have conversations, to sit down, and not have you work in a bubble. You know, why not consider retaining earlier? But that does force you, I think, to really come to grips with what you're actually asking the expert to do at the outset, and not think, okay, down the road we'll eventually figure out what we want the experts to do. Like, what is it now?
Yeah, and in a phased kind of approach. I think the other thing that quite frankly comes into a lot of these problems with experts is so many cases settle that a lot of experts want the work and are looking, thinking that this report's actually going to end up in a settlement and I'm not going to actually have to testify about it.
Yeah.
And you just see that sometimes the quality in some of these reports or the independence is not what it should be if it was going to go. And so there's, you know, you fundamentally have to think when you're doing this work, this is going to end up in trial. And if you don't take that perception, you're going to get yourself into trouble.
That's
Yeah.
right, because we're taught, approach it that you have the decision, so you've gone through the trial and work your way backwards, right?
Right.
Yeah.
So. But I think, you know, just to bolt onto that quickly, even if you're just in a settlement negotiation on the telephone, if they've got one of the hired guns on the other side, and I ask myself, what's their leverage over me?
Right. Right.
And then you find yourself at a mediation with somebody, let's call him hypothetically George Adams or hypothetically Duncan Glaholt. They're going to point that stuff out to you. So again, you're bargaining. You've come to a gunfight with a knife. Not even a knife. You've come to a gunfight with a banana.
Right.
You're not going to negotiate
that's right.
a good settlement. I mean,
Yeah.
it's all for naught.
Yeah.
So
Yeah.
Again, I think the idea on major construction claims that you're just going to cut corners and just not adhere to any of this stuff, you're just wasting your time and money.
Agree.
All right. Let's talk a bit about communication best practices and disclosure obligations. So starting off with Steve, keeping in mind a client's budget restraints and timelines for your dispute, what access is most critical for you to have with clients and their personnel?
So, you know, speaking from the financial records and the financial, you know, number crunching exercise, I mean, clearly accounting people that understand how the documents were pulled together, how the time management system worked, how the procurement system worked, how that comes together. But again, and I started today with this concept, the financial documents alone don't speak for themselves. So we fundamentally need somebody who lived and breathed the project to help us understand why it is that there's this much cement consumed or there was this, and somebody who was there living it and somebody who took photos of the issue and that type of thing. So it's kind of a two-headed, you know, monster we're looking for. We're looking for the financials, controller, CFO type, but we're also looking for the guy who was on the ground in the project manager. I think those are critical.
Ali?
Yeah, for myself, I find an initial interview with the project personnel, so the construction manager, the project manager, those individuals who really were involved with the project, just to understand what their planned execution of the work was, what the actual execution was, why that changed. Another thing that's helpful and it helps accelerate our time to perform the analysis is just to guide us through all of the project documents. You know, what kind of records were maintained on this file. I find that usually helps accelerate the process of analyzing the file.
Now, you guys have mentioned some different individuals and different roles you'd like to meet with. Does that mean it's helpful to meet with them together, or is that not the best way to go about it?
I typically like to do them, one after another. So I'd like to get my head around what the numbers look like, and then start asking the project people about that. I think the other, sometimes you can run into a bit of a problem too, where as an expert, we can't rely on secondhand, where the project manager told us this, and this is why we booked it as this cost, right? We need to get that. If you're going to be independent and objective, you actually need to ask the person, who was there and did it. So you got to be careful about the secondhand information as well.
I just want to add to that, whether or not you meet with them individually or as a group. My preference is to meet with them individually, and the reason for that is I want to try and avoid groupthink. Everybody has, the project team has a view as to what happened, and they maintain that view, but it's, I think, important to get them individually and from their perspective and hear their side of it and hear how they perceived it rather than fall into a trap of groupthink. I've had a file where there was definitely groupthink, and almost everybody told the exact same story. It was just incredible, and it didn't go well for the client, unfortunately, but you want to get away from groupthink and hear the perspective of each individual, because they all have different functions to perform, and they were all involved in different aspects of the project. So I would meet with them individually.
Brendan, do you have any thoughts or concerns about experts interacting directly with client personnel?
Yeah, again, I think I would start with what I mentioned earlier. It depends on what type of expert it is. I think if it's a consulting expert, far less concern. And I think, just as a practical matter, recognizing how expensive all these things we're talking about is, if you're looking ways to manage budgets, I don't think you need to have a lawyer at the table with the client and the consulting expert every step of the way. Now, I think it's a mistake in any kind of enterprise like this to have people who are in the dark and not aware of what's going on. You need to keep people informed and updated. And what I've found is very effective, particularly with the consulting experts, is to meet with them and the client group on a monthly basis as you're preparing. And so everyone's in the loop and updated, and that's all very positive and very good. Testifying experts a little bit different. Again, just remembering some of the cautionary tales we've told, the recent Ontario government case, the McNamara Newfoundland case. You don't want to find out later that, notwithstanding the best of intentions, but because of very real commercial pressures and just very natural human nature to want to win and avoid the uncomfortable facts and just focus on what we're comfortable with, our good facts, is that we don't have a set of meetings with experts that devolve into a potential risk that now the expert will be viewed as someone who's more in the camp of an advocate and less of that impartial person. Now, again, some experts have different strengths and are better at certain things than others. I think, a guy like Steve, I maybe less concerned that he's going to be a marshmallow that's just going to be crushed by that groupthink, as John alluded to it, and not remember to ask any of the questions that he needs to ask. On the other hand, it's nice to have a buddy in those certain enterprises. The lawyer there to be able to re-emphasize with the client why we need to ask these questions, why we need to overturn these stones, and it's because we're trying to help them present a case that's going to win, or give them good leverage in the negotiations. So it's to make sure those fundamental guideposts are maintained. I do think you want to have the lawyer involved in those meetings when your testifying expert and your client and your witnesses are interacting. Now, that being said, you have to be living in the real world. So if it's just a matter of a telephone call where, hey, Joe, where do I find this document? It's not like you need to artificially pause and say, okay, we need to chase down this dude at Glaholt and conference him into this quick little conversation about a document. I'm not saying that, but I'm saying the important engagement where we're going to really get into the facts of the matter. We want to make sure those guideposts are maintained and that you're getting value for money for your lawyers, candidly. Because, John said, yeah, he made an important point there. Don't just throw the expert under the bus when the case goes wrong. Why weren't the lawyers doing their job? In fact, actually, that's the most fundamental point of all. That's one of the things in the Advocate Society principles. I'm not going to list all 9 of them for you because that would violate the Geneva Convention on Torture for me just to lecture about that. But one of them is essentially, don't throw your expert under the bus. In other words, don't expose your expert to unnecessary criticism by the court or the arbitral tribunal lawyers. Don't throw your expert under the bus. So don't say, oh, wow, that McNamara decision was terrible, but it's all your fault, expert. How on earth did that happen? Why weren't the lawyers doing their job? Why weren't the lawyers there making sure that those meetings didn't devolve into that sort of advocacy piece? Why weren't the lawyers there making sure that the right documents were reviewed, that the uncomfortable facts were pursued as well? Why weren't the lawyers doing their job? Actually, that's what the Advocate Society tells us to do. Do your job and don't throw the experts under the bus. So I've forgotten the original question, Derek. I got it.
But Brendan, that raises sort of a knock-on effect, which is that the clients have to understand that, and the clients have to understand that you need to provide sort of access to documents and personnel so that the expert can form an unbiased opinion.
I also think it's important that if there's warts in the case that are coming up with your expert meeting with the key people on the project, that legal counsel is aware of those before they show up in our draft report. So if you're actually there for those fundamental, hard questioning big meetings, I think it's really important.
Yeah.
Really important. So
I'm sure you all would agree that those warts will come out eventually, and it's probably best to have them brought out by your own team to consider before it's at a trial or at an arbitration hearing. So,
Because the warts are rarely insurmountable, by the way, in these types of cases. There's usually a counter explanation. Again, but if it's, you're far better off to find out early. There's no doubt about it.
are there any other thoughts on how to avoid tainting experts with that sort of groupthink or that narrative that might result in the perception of them being an advocate?
Well, yeah, that's an interesting way to put it, tainting your expert, because I think that you taint your expert by keeping them in a bubble. If you don't allow them access to people, access to documents, and you're telling them more or less the opinion that you want based on what perhaps the lawyer has reviewed or perhaps what maybe one individual from the client has indicated. And so what you've then done is your expert is no longer impartial, they're no longer unbiased, they're no longer independent. They have the corporate narrative, I think. However, the corporate narrative, I think you can overcome it because there's really two narratives at play. The first narrative is what the people tell you, what the project personnel tell you, and the second one is what the documents tell you. And never underestimate the value of contemporaneous documents. And they could be as simple as photographs that are date stamped that tell a different story than what the witness is saying. So I think you